Hey everybody. We got a couple of motions responses that we have today that I'm gonna have you guys to hear. Okay, I have my guest. Two minds, one mic. All right, here we go. There she is. She is here to read for me. She felt really bad for me this morning.
Good afternoon, everybody.
Good
Am I
afternoon.
too low, Sylvia?
No, you good. You good.
Okay. I'm on a whole different thing now, so it should be better for everyone.
Okay. All right, guys. The first one is a motion in response from Mr. Harvey. He responded to the state's opposition, and then we have some more. Okay. Oh, thank you, Big James. Big James said I did a good job earlier, so Big James loves me. I feel the love. I feel the love. What's, what you banging on? What you banging on, man?
Right.
You ready?
I'm ready.
All right, let me get myself together, put my stuff up for you. Still also send a motion back. So we are going to be a very busy evening, guys. So I'm going to put it up for us to review. All right, here we go. This was sent at 4:42 today. So without further ado, to phone to mic to I can't remember the
All
name. Okay,
right.
here
Uh,
she is.
all
Thank
right.
you.
All right. State of Georgia versus Quamarvius Nichols. Defendant Nichols replied to the state's response to Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge. Comes now the defendant, Quamarvius Nichols, bind through undersigned counsel and files his reply to the state's response to Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge in the above captioned case. In support thereof, Mr. Nichols shows the court as follows. Number one, defendants were goaded into a mistrial. In Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge, Nichols adopted all motions and arguments for a mistrial as filed by co-defendants. As adopted, Nichols' first argument for mistrial was that he was goaded into moving for a mistrial. Regarding this basis for mistrial, the state has offered only the most cursory response to Nichols and co-defendants. In the state's four-sentence response, it appears that the state has merely given the state's opinion, which is the state does not agree with the defendant's characterization of the events. The state did not proffer the state's own characterization of the events. The state did not submit facts in support of its conclusion. The state did not present any legal argument upon which the court could or should rely. Although the state's reply gave a little to which Nichols can respond, Nichols replies as follows. Nichols moves this court to deem the defendant's characterization of events as accurate, inasmuch as the state did not provide any facts or evidence to the contrary. Nichols moves this court to accept the arguments as made by the defendants because the state did not proffer any argument of its own in rebuttal. Nichols moves this court to accept all of the legal basis offered by the defendants as grounds for a mistrial. Because the state did not submit any legal arguments to the contrary or even in furtherance of their unsupported opinion, Nichols urges this court to take note of the seriousness of the defendant's motion, which specify in detail the events which have acted as denial of the rights to a fair trial. This was followed by the state's cynically dismissive response, which seems to consider the right to a fair trial as a trifling afterthought, rather than a pillar of the criminal justice system guaranteed by the Constitution of the United States of America. The Georgia Constitution, numerous statutes, centuries of case law, and the rules of criminal procedure. The lack of regard by the state for the fundamental issue of fairness is strongly evidenced by the paucity of the state's response, and we implore this court to take notice. A fair trial is not optional. It is foundational and mandatory. A trial is not considered fair simply because the state says so without explanation. The defendants in this case were in fact goaded into moving for a mistrial as described in their motions. This is not refuted by the state. We move this court to grant a mistrial on that basis. 2. Constitutional implications and violations. In Mr. Nichols' motion for a mistrial in objection to the mid-trial substitution of the trial judge, Nichols further relied on his right to a fair trial under the 6th and 14th Amendments to the United States Constitution, as well as the concomitant provisions of the Constitution of the state of Georgia. The state responded by arguing that this claim was made and rejected in McIntyre v. State. First, in McIntyre, the Supreme Court of Georgia specifically stated, "We assume for purposes of the appeal only, and these rights are implicated by the mid-trial substitution of judges." After assuming that constitutional rights are implicated in a mid-trial substitution of a trial, the court went on to hold that the defendant in that case had not shown that he was harmed by the substitution, and therefore, under the circumstances of that case, the procedure followed in the trial does not require reversal of the judgment of conviction. ID. The court also stated that in Georgia, the temporary absence of a trial judge without suspension of the trial is not a basis for reversal unless the complaining party shows prejudice resulting from the absence. ID. The state's comparison of the case at bar in McIntyre is entirely unavailing. In McIntyre, the trial judge's absence was to attend his grandson's funeral. Here, the trial judge is not absent for purpose of a finite leave. He was recused. In McIntyre, the court specifically took note that the trial was not suspended. Here, the trial was suspended for over a month and counting. Dissimilar to McIntyre, Nichols has not been convicted and has been on trial for over 19 months prior to the permanent removal of his trial judge. Nichols' trial is the longest trial in Georgia's history, which includes over 6 months of testimony, some of which was conducted by a later removed trial judge after motions for his recusals were filed, which were subsequently granted. One moment. Further in McIntyre, in the concurring opinion, the court noted that defense's limited request for review of the previous proceedings included no further discussion or requests pertaining to the matter. In the instant case, Nichols specifically objected to the substitution of the trial judge mid-trial and has submitted reasons why the substituted trial judge needs to be familiar with the entire record. The impracticality of this requirement and the harm that is caused by the substituted judge's lack of familiarity with the entire record. The state concludes by noting that in McIntyre, the court specifically referenced People v. Espinoza, in which the Supreme Court of California held that the substitution of the trial judge for the defendant's guilt phase did not violate his rights. In stark contrast, in Espinoza, the trial judge was present until after the jury reached a verdict. The defendant's application for modification of the jury's sentence of death was the matter considered by the substituted judge, replacing a seriously ill judge after reviewing the transcripts of the trial proceedings, which occurred before his substitution. None of these facts exist here. Number 3, directed verdict and other decisions to be made by the trial judge. In the state's response, the state seems to acknowledge that directed verdicts are available, but ignores the inconvenient fact that familiarity with the record is a prerequisite for the court to make that decision. Neither does the state explain how the court will make other necessary decisions without being present or familiar with the record. One of the most consequential powers of the trial judge is the authority to act as the 13th juror. As the Georgia Supreme Court held in Wilkerson v. State, even when the evidence is legally sufficient to sustain a conviction, a trial judge may grant a new trial if the verdict of the jury is contrary to the principles of justice and equity, OCGA 5520, or if the verdict is decidedly and strongly against the weight of the evidence, OCGA 5521. When properly raised in a timely motion, these grounds for a new trial, commonly known as the general grounds, require the trial judge to exercise broad discretion to sit as a 13th juror. In exercising that discretion, the trial judge must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of witnesses, and the weight of the evidence. Wilkerson v. State. Emphasis added. As J. Bethel further explains in his concurrence, collectively OCGA 5520 and 5521 are commonly called the general grounds and have been referred to as the 13th juror rule by the bench and bar of this state. These rules create a weighty and long-standing power designed to provide the trial court with an opportunity to avoid any injustice. As the court has noted, the general grounds ask whether the trial judge is personally satisfied with the jury's verdict. Manuel v. State. See also Mills v. State. Describing motions asserting the general grounds as an appeal to the judge's judicial conscience. Trial judges retain the strongest of discretions when reviewing motions based on the general grounds. Manual. This authority is vested in the trial court and necessarily involves questions of fact and the independent weighing of evidence. Therefore, we must decline to substitute our judgment for the judgment of the trial court. ID at 577, 578, emphasis added. In this case, the mid-trial substituted judge did not attend over half of a year of testimony. Trial thus far has not been just fact-laden testimony of custodians of records. Rather, trial has included crucial testimony which must be personally observed and experienced by jurors, including the 13th juror. Take, for example, the testimony of a witness whose antics on the stand led to his jailing for contempt. The testimony of a witness who accused another state witness of having engaged in abuse of authority, attempts to influence witnesses, and improper sexual advances. The testimony of a perpetrated witness to alleged crime who testified that no such crime was in fact witnessed. The testimony of a witness who directly contradicted previous sworn statements and now testified that those previous statements were fabricated. This trial may very well hinge on conflicts in the evidence and the credibility of witnesses, as contemplated by the Georgia Supreme Court in Wilkerson. Accordingly, in this case, it is simply not possible for a judge without personal observation of the witnesses and their testimony to be our 13th juror. Further, Nichols notes that the original 19-month trial judge made numerous contingent decisions addressing admissibility of evidence, the need for curative instructions, the need for severance as the case progressed, etc. The state did not dispute these facts and offered no argument specifying how the mid-trial substituted judge could make these rulings without familiarity with the entire record and the testimony of witnesses. Unfamiliarity with the record. The state appears to concede that most jurisdictions have adopted rules of procedure requiring a substituted judge to certify on the record their familiarity with the previous trial proceedings. In Georgia, this is interfered from the U.S. Constitution, including 5th, 6th, and 14th Amendments, as well as the Georgia Constitution and its requirements for due process and a fair trial. The court's familiarity with the record is needed to make every decision, including, but not limited to, litigation decisions, admissibility decisions, credibility decisions, directed verdict, acting as a 13 juror, jury instructions, severance, mistrials, and more. Furthermore, logic, fundamental equity, and society's interests all support the proposition that, particularly when a defendant's liberty is at stake, the court must know what has occurred during the trial to ensure fairness and to make informed legal rulings. Anything less simply does not conform with the concept of a fair trial. Lacking any cogent rationale, the state resorts to its usual slippery slope scare tactic, disingenuously claiming that accepting Mr. Nichols' arguments risk setting a precedent that would preclude mid-trial substitution of any judge in any case. Comparing the length and issues which have occurred during this trial and a normal trial is like comparing a minnow to a whale. Here, Mr. Nichols merely contends that in this case, given the I can't say it now, length of the trial, the amount of testimony which has already occurred, the need for personal observation, the vast number of deferred rulings in various states of limbo, the witnesses which were excluded from video recordings, and the portions of the trial which were not recorded at all. This court cannot timely and adequately familiarize itself with this trial record and cannot suitably proceed without such familiarization. Recess of trial. The state concedes that mid-trial recess is unusual, but misses the point. Recess is the basis for a mistrial when it results in an unfair trial. The jurors have been sworn in for 9 months. The trial has been actively suspended for over a month and counting. The jury continued to hear witness testimony after the defendants moved for the trial judge's recusal. The jury cannot erase the portion of the trial. The jurors are expected to resume trial under the auspices of a new judge, and if that won't have its own implications in their minds. The jurors are expected to remember what they heard and observed months ago. The state has offered to help familiarize this court with the previous proceedings. Even if that was possible, how long will that take? While the jury remains held in absence, not to mention the state has over 100 witnesses remaining. Unfortunately, this trial is irretrievably broken, and the jury cannot reasonably be expected to resume its role unaffected. In arguing that the recess is not disrupted, the state relies on precedential cases where a recess occurred during jury deliberations when a juror was in a car accident. Defense counsel's illness prompted a recess. A recess based on defendant's hospitalization lasted more than 1 month. From these non-binding off-topic anecdotes, the state somehow concludes that the recess in the instant case is not a basis for a mistrial. This is nothing more than the state's desperate attempt at misdirection. The facts in this case are entirely different from those who cited by the state. In this case, the recess is a further disruption to the jury necessitated by the recusal of the trial judge, not an accommodation to illness or injury. Severance. Once again, the state misses the point. Nichols' argument in his motion and objection was that the previous judge had repeatedly stated that Mr. Nichols' request for severance was under advisement and could become necessary at some point. This court was not present as the case has evolved and will therefore be unable to make an informed decision based on a record in which the court is unfamiliar. Wherefore, the defendant moves this court for a hearing on this motion for mistrial and objection to the mid-trial substitution of the trial judge, this 29th day of July 2024. Bruce Harvey and Nicole Westmoreland.
Okay, check your email. There's another one. All right, guys, we got another one. We're going to keep going. Shout out to Dee Dee. Thank you for the super chat, Dee Dee. I'll get the massage next month because you know this super chat comes next month.
You want the addendum or motion?
Motion, please. Because look at the time. Which one is more recent?
One was 5:20 today.
What's the time the other one?
It's 6:11 my time.
Okay, let's do 5:21.
Okay. What time was the? Let's see. The other one was held at 5:09.
Oh, the other one's 5:09. The first one we had was 5:09, right?
Yeah.
Okay.
That's the amendment and supplement to the state's motion.
Yeah, let's go ahead on and share this one. All right, there we go.
Which one you have up?
The Brady renew motion for Brady evidence. Is that the one? Yeah.
Okay, let me go back.
5:29.
Okay, got it.
520. I'm sorry, 520. You see it?
Yep, I got it. Ready when you are.
I'm ready.
All right. State of Georgia versus Jeffrey Williams. Renewed motion for all Brady evidence to be provided in stanter. Comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this renewed motion for all Brady evidence to be provided in stanter. In the above reference case, in support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above reference indictment. 2, Mr. Williams has, from the inception of the case, demanded the prosecution to fulfill its duty under Brady v. Maryland. Under Brady v. Maryland, Supra, and its progeny, the suppressions by the prosecution of evidence favorable to the accused upon request violates due process, where the non-disclosure is material to either guilt or to punishment, irrespective of the good faith and the bad faith of the prosecutor. This includes the suppression of impeachment evidence that may be used to challenge the credibility of any witness. See Platt v. State. Mr. Williams has demanded Brady evidence to be provided in stanter. Mr. Williams again asked for this honorable court to order the prosecution to provide all non-disclosed Brady evidence in stanter. It has been proven that lawyer Love and or lawyer Hilton have not provided Brady evidence and have in fact attempted to hide same from undersigned counsel. See ex parte transcripts dated June 10th, 2024. Wherefore, Mr. Williams respectfully requests a hearing on this motion and the conclusion of same, asks this honorable court to grant the above requested relief and order the prosecution under penalty of mistrial if the evidence has not been turned over to undersigned counsel. This 29th day of July, 2024, respectfully submitted, Mr. Brian Still and Mr. Keith Adams.
All right, we're about to put up the other one, the last one. All right, let's go. Oh, my back.
You said go?
No, hold on. Let me pull it up. I got to pull it up. This is from the state. Y'all, this is from the state. This is someone addendum. Okay, this is the state.
Yep.
I'm ready.
Okay. This one is State of Georgia versus Jeffrey Williams. It is amendment and a supplement to state's motion to compel defendants' compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. Interesting. The State of Georgia, by and through Fonnie T. Willis, District Attorney for the Atlanta Judicial Circuit, hereby moves this honorable court for relief regarding material in defendant's possession, which defendants have not been provided to the state in discovery despite its intended use as substantiated evidence in the case. The state hereby amends the state's motion to compel and to exclude, to correct the following, and to supplement the same. As the state shows this honorable court below, subject to the matter set forth herein, the state incorporates by reference its previous argument on the issue and hereby supplements those arguments with the matter set forth in the pleading. Supplement argument and legal authority, material at issue. Defense has acknowledged that it has intentionally withheld materials and as and is in possession of materials but have not turned them over through discovery. 1. Amendment and supplement to state's motion to compel defendants to comply with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed to the state. For example, one of the state witnesses is Adrian Beam, who the state's evidence shows was a co-conspirator with defendant Williams is in an indirect armed robbery. The weekend before the day cross-examination of Bean was to begin, counsel for defendant Williams disclosed a recording of Bean, which had been in counsel's possession since January 2023, in which Bean claimed that the defendant Williams was never involved in the armed robbery, in which Bean claimed that the police told Bean to put defendant Williams in the crime. Defendant Williams presented this statement not simply as impeachment evidence, but as substantiated evidence. Further, based upon information provided by Bean to the state, the recording was only a portion of the recorded statement at issue. The failure to present the recording timely prevented the state from obtaining a complete copy of the recording, which appears to no longer to exist, such as the statement cannot now be considered in its entirety. For another example, defendant Williams has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts, "We killed Nutt," referring to Donovan Thomas. Copeland is the state's witness whose testimony currently is ongoing. The defense has not provided the state with such recording or made it available to the state. Despite specific and direct requests for it, the state assumes defendant Williams intends to use the recording, if it exists, not simply for impeachment purposes, but as substantiated evidence. Given defendants' explicit and deliberate decisions to withhold the material specifically mentioned above, the state suspects defendants possesses additional materials which they would submit through cross-examination, which they would want the jury to consider as substantiated evidence. Georgia discovery. A defendant pretrial discovery responsibilities extend generally to materials which are within the possession, custody, or control of the defendant and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. OCGA 1716-4C1. These responsibilities also extend to reports of any physical or mental examinations and of scientific tests or experiments, among other materials. If the defendant intends to introduce an evidence in the defense's case in chief or rebuttal, the results of the physical or mental examination or scientific test or experiment. ID at C2. C. Use of inconsistent statements or substantiated evidence. In Georgia, a prior inconsistent statement of a witness who takes the stand is subject to cross-examination is admissible as substantiated evidence. See Agee v. State. Citation and punctuation omitted. While Georgia's discovery law does not explicitly apply OCGA 1716-4C to evidence used simply for the purpose of impeachment, it unquestionably applies to that second intended purpose, that is, use as substantiated evidence. D. Relevant similar federal laws. As with Georgia law, federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control, where the defendant intends to use the item in the defendant's case in chief at trial. Fed R. Crim Pro 16B1A. Although this does not apply to simply impeachment evidence, a defendant's case in chief does not apply to evidence which is offered both as impeachment evidence and as substantiated evidence of innocence. For example, in United States v. Young, the Fourth Circuit affirmed a district court's curative action against the defense in a criminal case for failing to turn over a tape of a government's witness, which the defense sought to introduce during cross-examination as both impeachment evidence and as substantiated evidence of innocence. See also United States versus Waddell. Denying government's motion for reciprocal discovery tapes based on defense's representations that it did not have them, but admonishing that if he's lying about actual, if not constructive, possession or control of the recordings, and later tries to introduce them during his case in chief, that evidence will be subject to exclusion. The federal discovery rules for civil cases specifically exempts from discovery evidence where a party's use of it would be solely for impeachment. And it says see Fed R Civ Pro 26A 1A I, similar to what Young said about the rules for criminal cases. This requires the discovery of material which is meant for both impeachment and substantiated purposes. As one set of commentators have said, if a party's plan to testify to one version of the facts and the opponent has evidence supporting a different version of the facts, the opponent's evidence will tend to impeach the party by contradiction. But if discovery of its kind of evidence is not permitted, the discovery rules might as well be repelled. Even those who have been most concerned about protecting impeachment material recognize that substantiated evidence must be subject to discovery, even though it also tends to contradict evidence of the discovering party. Says Charles Allen Wright and Arthur R. Miller, Federal Practice and Procedure. They are footnotes omitted. Conclusion and request for relief. Evidence to be offered as substantiated evidence is subject to discovery, even if it is introduced through cross-examination and even when it has impeachment value. While some such evidence is developed or acquired close in time to such cross-examination, here the defense is intentionally and deliberately withholding such evidence long after it was acquired. The state recognizes that both Georgia and federal authority instruct the courts employ the least extreme sanctions to remedy discovery violations. The state has moved this honorable court to exclude the evidence the defense holds in its possession in violation of OCGA 1716-4. Should the court deem exclusion a remedy that is too extreme, the states request this honorable court to issue an order, one, directing defendants to permit the state to inspect and copy any and all material a defendant possesses which the defendant intends to admit as substantiated evidence, even if the material is also impeaching of a witness. And two, directing that where the proffering defendant intentionally withholds such material that it would be admitted, if at all, solely as impeachment evidence, and with limited instruction prohibiting the jury from considering it as substantiated evidence. Respectfully submitted this 29th day of July, Adrian L. Love.
All righty, good people. What do you guys have to say? You know what? We got to talk about this. What do you think about what was just read? Two mics. One mic, two heads.
Yes, JC is fine.
So what do you think of the first motion that was submitted by Harvey, the response to the state? Because Harvey is not going to let it sit. He's like, you know what? Before I even give my argument, let me just put it on in writing because I got to get these people straight. Okay, what do you think? What do you think about what he said?
Well, he has all great. His motions are of great value here, that the judge should be looking at very closely, because it is really, really good on.
Did you think just said you got mail?
That's my phone.
Can you believe that's a back in the days? You got mail.
That's why I
Tell
put
you.
it as, let me mute this. I'm sorry.
Yeah, did y'all hear that? You
Do you
got mail.
remember that from way back in the
That
day?
just before half of y'all was born.
Yes, that's why I used
Yeah,
it.
LOL.
I love it. I love it. I muted it. Sorry. I think the number one thing that he covered, obviously, that the defendants were goaded into this mistrial. And I think that is um, very, very important here. I think that is like the highest of importance because they were actually goaded into this mistrial. So all these other motions can say whatever they like, but it does not cover the ground of every single defendant in that courtroom has been definitely goaded into a mistrial. So having that number one, the state not proffering the state's own characterization of the events. Um, the state did not submit facts of support of its conclusion. The state did not present any legal argument that the court could even rely on to even look at any cases or the face value of the case. So him covering those grounds just off top is gold. But the constitutional rights, like that is one that can't just go fly over anyone's head. Um, I think that is really, really important because their 6th and 14th Amendment has been violated. And I think America and people in the legal field and in the law field, and um, there was one that I seen of a judge that gave its opinion and was so beside herself that it's even at this point that this has gone on this long with the type of amendments that have been violated. So the sufficiency, and then also he had covered the directed verdict and other decisions to be made by the trial judge. I said, if you remember back, I said from the very first day, it is impossible for this judge to pick up where Glanville left off. It is impossible. It is not even if she spent an entire week indulging, she has missed entirely way too much that just can't go over anyone's head.
Yeah.
I think that his response was accurate. It was very to the point, and he hit all the key references that needed to be hit in response to it. And also the biggest thing, if you look at his motion and you compare it to the state's motion, he had cited over 8 cases that can be referenced back to. And he also went into detail of what the state put for the cases of reference and put why this would not apply here. And I think that is very important because a lot of the case laws, like I read the other day for you and I pulled them up and we talked about them on live, they were not sufficient for what the actual subject matter at hand was. So I think throwing out cases that don't apply does not help you either.
That's true. That's true. Um, AR asked, what order do you think the judge will go in the rule on these motions? Start at the big ones like the mistrial. I think they're gonna do it in order. Who has they have received and who in order of reciprocate received or
To
whatever.
be fair, the very first one that needs to be addressed tomorrow morning at 8:45 a.m. are those bonds.
But were
Okay?
they first? I think Matthew was the first one. His was the first one. Okay, here's another motion I'm going to send you that we have. Hold on, so it just popped up. Hold on. Hold on. This is from Mr. Steele. Hold on a second. I'm going to send it to you.
And you
Uh-oh.
know, this judge is going to freak out with all these motions coming in after the fact. I mean, she might get up there and say, "You guys had a week. I'm not accepting this." So all this stuff that we're reading today could just simply just be tossed to the side because all of them are outside of the deadline,
At
unless
least the ones we're reading now. At least the one. Well, what's the names is a reply to love. Nichols is a reply to love.
and why I say that bonds needs to be the first one, because obviously there's a lot of litigation that still needs to happen and arguments on the motions. And so this is going to take a little bit of time, right?
And the
So
reason why I say Matthew, because he put it in first. First come, first serve. That's the way I see it. That's all.
why I think she should take them all at face value, have every single bond motion in front of you and go one by one. Because as it's going through the rest of the motions, regardless if that takes 2 days, 7 days, 14 days, however long this judge takes, it's just another day longer that they have been withheld bond.
Okay, look at your motion, and we can read this to them too. We got one more motion before you guys come up.
Response 3.
Yes, ma'am.
All right. This one was actually at 5:20. This one was exact time of Love's. They were filed at the exact same time.
Mm-hmm.
State of Georgia versus Jeffrey Williams. Response to the state's proposed witness list comes now. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this response to the state's proposed witness list in the above reference case. In support of the response, Mr. Williams shows as follows. Number 1, Mr. Williams is innocent of all charges in the above reference indictment. Number 2, on Friday, July 26, 2024, the prosecution provided a witness list with an attachment declaring exhibits.
So that means they sent some stuff that we don't see, that it was not put electronically, because I did not see a witness list.
Try to go back in there now.
No, it's not there. It's not there.
Not?
I just got the ones that just came in.
Oh, that's weird. Usually exhibits are shown.
No, I think they just emailed it and never put it through the electronic system.
Got it.
Go ahead.
Number 3, the perpetrated exhibit simply states generalities such as text messages, photographs, jail calls, and the like. The general description of exhibits does not help clarify for Mr. Williams what specific text messages, photographs, jail calls, or the like are being sought admissions before the jury. Without specifically objections will be made. What?
Contemporaneous. I got that one.
You did good on that one.
I got a word, y'all.
I was about to be tongue-tied when the state attempts to introduce same. However, the goal is to provide notice to the party of what exhibits are expected to be introduced at trial. Then Mr. Williams respectfully requests details viewing of these exhibits so that timely objections can be made outside of the presence of the jury without potential bench conference delay with the jurors sit idly by. Wherefore, Mr. Williams respectfully requests the hearing on this response and the conclusion of same. Ask this honorable court to grant the above requested relief. This 29th day of July, Mr. Brian Steele and Mr. Keith Adams.
So that means they...
okay, so wait, there's a footnote 1 that does give a little bit of info into that. Footnote 1 says Mr. Williams has also named approximately 60 persons on his witness list and has provided the prosecution since approximately October 2023 with exhibits. Once the prosecution rests its case, Mr. Williams will have a clear view of which witnesses and exhibits he will seek to introduce and can, if desired by this honorable court, provide this honorable court details of said witness proposed exhibits. So they're saying, okay, well, they had 100. We have about 60. So what are we doing here?
Remember, she was supposed to make it as streamlined as possible. Remember, the judge asked her, they're supposed to have it where it's listed, where what thing it goes to, what evidence. Remember, she had asked that?
That was so long ago that they were directed to do that. And
No,
then
no,
they
no, no. I'm
were
talking about this
redirected
judge even
again.
asked.
Yes.
Even this judge asked. This judge
Right.
asked that.
I just can't. There's a lot to unwrap here, right? Like Harvey, what Harvey said, Weinstein had a good one in. And all of the motions that we've seen so far with the state that have not been sufficient in case law, and what case law they have referenced, they do not pertain to the situation at hand. And if you actually pull up the case law that Harvey does cite, it is in reference to what has happened here already, not what is happening, what has already occurred, past tense. And it still has been streaming along as I would like to have seen that they falsified the warrant. I would like to have seen that on. I would like to have seen that not prosecutors, excuse me, that their detectives that they had boots on the ground have been caught lying on the stand. Those are all things that are all very important. It's just they're using irrelevant cases and they're saying, because I'm the state, this is why this should happen. And because I'm the prosecutor and I am the head DA, that alone should decline them at face value. And that is not how it works. When you reread that other motion that they put in, it said that based off of their position, that it should be denied based off of that. And they shouldn't have to be called because there's nothing that the transcripts can't provide. Well, that's not true, because you could bring up them pieces off of the recordings to show she interjected herself. I have never seen a prosecutor have their own witness on the stand saying, what did I tell you this day? What did we talk about on this day? What did we do when we met on this day? You don't see this kind of stuff. So seeing this kind of stuff, you know that they're using the front and the bottom of their hands. So they were showing one and then they're turning it over to disclose the rest, and then turning it back over, showing a little bit more, and then turning their hand back over, and then we didn't do anything. And that's not the case here. I think it's going to be really, really important to see how the judge's stance is tomorrow. But there is no way she can continue, because it has been a mess pre-trial. It has been a mess pre-trial. That whole jury selection process was an entire wreck. That alone should have did it. They requested a speedy trial. They were denied that. However, they weren't denied that because there was once an order in Fulton County that Glanville had suspended all speedy trials. Well, they were outside of that timeline. So there's no
they
reason.
removed it. They removed that by the time.
Correct.
That
So there's no reason that didn't even happen. And if you listen to DA's interview that she had gave with a news station, she said that courts are backed up because the ones that request speedy trials, they have to give them a speedy trial. Well, how come this indictment doesn't qualify for that? And how come this indictment doesn't qualify for bond? And how come this indictment doesn't qualify for your endorsement letter? What is the difference here? And there's only one underlying reason that could be the difference, that there is a personal relationship connection somewhere. Because no, this is, in all honesty, if you go back and watch that interview where she had the whole team behind her, and she said that she was a prosecutor for 16 plus years, and before she got into seat as a DA, she made it her promise that she was going to put extra resources out there to have this gentleman that was killed justice. How come that same justice has not been afforded to the young men that have already lost their lives? Why their mothers are not important as this mother? They are all deceased. They are all no longer here. So why don't they get that same thorough investigation, extra people on the ground, and made it your business to make sure that's through? What about the other ones? Or what about the mother at home that your daughter was raped and killed, and you're still waiting for a day in court 6 years later? What about her? So I think of everything as a whole. I look at the entire picture, why these other ones are not as important. This is personal. It shows, it's clear, it's evident, the speeches back it up, and it's sad because it happened in front of America. And here we all are joined together stating it's a big mess. If I'm wrong, or if my point of view is wrong, then I'm wrong. But this is how I feel. This is how I feel. It's enough is enough. Enough is enough. Because all these young gentlemen that lost their lives and their children have to go on without a father. Their mother has to go on without a son. The father has to go on without a son. Everyone is equally important, not just this gentleman. It's not like this gentleman was a mayor. You guys already promoted him from the DA's office as head of a gang. So head of a gang member is able to get extra resources and boots on the ground, but the other ones cannot. So the other ones can just kill themselves. Make it make sense, and make it make sense for the people. Everybody is important, and everybody deserves the same type of justice. You can't just deliver justice where you have your personal relationships. And I believe that she did state on air that he was a very, very special person to the community. So which community are you speaking of? Yours? Because your reports are stating that you need extra resources and extra funds to your county because gangs are out of control. So you have to make this make sense. That's what I'm saying. What do you think, Miss Sylvia?
Hold on a second.
Or did I get a little too deep?
We went another route. Hold on a second. I'm just trying to get something.
I think it's really time for the people really to speak how they feel and not these little bits and pieces. Get the full picture out there. America knows, America sees. And shame on you. Your very star witness that you relied on, that you just betted on. Um, you tormented him enough and thought he still was going to work for you and still cooperate with you, but you tormented him to do so. And then because that didn't work out, now you're scrambling, and here we are. And if the people really dig in to see how many funds were requested to have extra divisions and all of that put into their unit to make it stronger and to be able to seek justice, this was pieced together by word of mouth. This was literally pieced together by word of mouth. That is crazy. And if I was that gentleman's mother, I wouldn't want justice from somebody who handled me like that on the stand. No empathy, no anything. Just throw the evidence right in front of me. Who is this? Is this your son's vehicle? And you show it 6, 7 different angles, like the car was going to change or the truck was going to change. And then you piece together Instagram, oh, this is what he said. And it's a lyric of a whole different rapper. How embarrassing. And everybody's impeached. Let's talk about it. Everybody's impeached. They said years of investigation went into this, but then it came out it was 1 year. And this is all they got. If I'm working at the next county over and I see one of them come for a job, I'm going to say, absolutely not. Absolutely not.
Okay, I had made a statement on Twitter, right, in regarding for it to go all the way to the end. And some people misunderstood what I'm saying. I would rather for them to get a not guilty verdict instead of mistrial, because the way that these people play so much, they try to bring those cases back. I don't like that. I'd rather just a not guilty, and they don't want to ever have to deal with this again.
Well, absolutely.
Don't you guys agree? Because once a person's found not guilty, they can't bring it back.
But you also have to remember, when you have a certain level of fame, these type of things will come at you, and you will have different angles trying to tear you down whichever type of way. And my only advice is to all the young gentlemen out there. I got sons too. And I always tell my sons, you could come from the tree and the grass come from the same place in the ground. But when you get to a certain height, you just can't go back down there no more. And it is what it is.
See, the thing is, because what I've heard from, what they were saying, that it's a possibility is more likely for it to come back. So
that jury's coming back confused.
No, with the jury coming back, I'm saying with the jury coming back saying not guilty, then you already know that's it. There's no more. But if they come back and then they're gonna do they're not gonna do it with prejudice. The way these people do is so crooked around here. I don't know, y'all. I'm sorry.
Would they already have overturned, if it were to, if it were to continue and it would go to appeals, they already have a direct reversal on that note, right? So
Yeah,
it's
and let me
not
tell you, if
standing on its heels no matter what.
but I'm
And
saying even with I'm telling you, the Boosie situation has caused me to think like this now,
I
y'all.
understand.
The Boosie, because it was dismissed, right? And it came back. I don't want none of this crap to come back because then they come and say, okay, the law changed and blah blah blah, and it's coming back to them. I don't want that. I want them to be found not guilty and let it end.
Of course. I mean, of course, I think that is
I know it's
America.
federal, but the way these people do around here, I don't trust anybody. I I don't
Absolutely.
trust none of them. I'm sorry. I don't. I mean, come on. You've seen the stuff that's been done.
Absolutely. Absolutely. I've seen it. I've seen it. And recently I've been able to dive into the conditions of that jail, which is even more concerning.
I mean, we could disagree, but I'm telling you, the way I see things and all these motions and all this stuff, you got people that's doing some
If I were a
crooked
juror,
stuff.
if I were a juror and we were sitting in that room deliberating, and that judge asked me, guilty or not guilty, my answer is going to be confused. That's my answer. I'm confused. Why am I here? 100 and some. They have consumed these jurors' lives. You guys have consumed these gentlemen's lives that are locked up. You have
And then,
consumed
and listen to
taxpayer
this, y'all.
money.
And listen to this. From what I'm understanding, it could put dormant cases behind, and they could have something going on right now. Because remember, they've been in jail, and there's so many different stuff that has been happening inside the jailhouse right now.
Yeah.
And if not guilty would be they free of all charges. This is a not guilty, free of all charges. Case dismissed. That's what I'm talking about. But all this extra stuff, they could be hiding this, hiding that. Come on, I
Well,
I just don't trust it. I'm sorry.
I
No, I'm not sorry. I just
I
don't trust
get
it.
that. I get that 1,000%. But my message, if I had a message to the district attorney's office, I would say, your office is already under investigation. The Department of Justice has announced this, okay? Not only for the jail conditions, but also you got other folks looking into the funds that were used and how they were used. So you got all these extra hands in this investigation. If I had that seat and I knew I had all those investigations going on that they are not privileged of, and they aren't privileged to sit in on it, and they're not privileged to know any of that information of what's coming, why wouldn't you clean up what everyone has already seen? That is my question. This is off of the case. I'm talking about for your building and for your well being. Why wouldn't you, when you have open investigations on your division? Why wouldn't you? They have already let a piece of information out that they have found discrepancies, inconsistencies, and other things that they're not able to speak about right now. So, why wouldn't you clean up the very cases that you brought on that you can see justice is not being served?
Well, go ahead, Didi. Hey, Didi. Thank you for the super chat.
No problem. I had to drive through Atlanta and I wanted to take you out to dinner, but I saw you wasn't feeling good, so I figured I'd do something else
Oh,
um
thank you.
instead. Maybe when I come through next time you'll be feeling better and we can meet up for dinner.
Okay, thank you.
Yeah. I think that no matter what, um, this trial is not going to be able to continue. But looking at that
But
motion
I
that
just
Fannie,
hope, listen, I just hope if it's not going to be continued, that it will be with prejudice. That's all I'm hoping for. I don't want no other thing, no other, I don't want any other mistrial. It has
and
to be
I
with prejudice.
totally, I I agree, and that's why they figured that when that Judge Krause did what she did, she had to put the, well, he wasn't wrong, but maybe he should have done it this way, kind of trying to soften the blow. But I see that still's not letting it loose. Here's the thing. I think that Fonnie sees where this is going. If you look at the state motions versus the defense motions, it's crazy. There's such a huge difference. The state is just they're just being outplayed. Like they are not, they're way, the defense is way above the league of the state. They just need to go ahead and sit down. I think what she's doing now, she's wanting whatever the defense has to be produced so that she'll have it for next time, because she's the type of person that unless they dismiss it where it can't be brought back, she will try it again because she doesn't know how to take a L. So what she's doing is she's preparing for that, and that's why she's asking for all of this stuff, because they can take all of the stuff that's produced and they can use it to better prepare for the second time around. Which, don't get me wrong, I've been saying from the beginning, I hope it doesn't come to that. But I think that she is covering all that. But I also think that no matter what happens, just be honest, Miss Sylvia. I'm gonna be honest with myself. If I got called for jury duty and the trial was going to last, I'll say a week, I'll even say 2 weeks, and I can't be on social media, I can't do this, I can't do that, I might could do it for 2 weeks. Think about it. They have been out for 4 or 5 weeks.
Hmm.
You cannot tell me. It is just basic human nature to be like, yo, what's going on? We've been out for a long time. You cannot tell me that they have not, in some way, shape, or form, know about what's going on. So let's just say all the motions, let's say the judge just throws them all in the trash and says, I'm not dealing with any of them. Let's call the jury
They
back.
knew before
They're
the
not
trial
going to have,
started.
Hold on. Let her finish. Go ahead, Didi.
okay, so even if the judge take all these motions over the last week and a half and ball them up and throw them in the trash, when they come back, I don't know how many alternates they chose. Honestly, if it's a jury of 12 with a case lasted 3 years, they probably should have chose like 36, at least 3 times the amount. I don't know how many they have, but I'm willing to guarantee that if all the motions get pushed through and we end up calling the jury back, they won't be enough to complete it. Not if they're honest. Because I'm going to tell you right now, anybody on this chat right now, can you, and I know there's going to be some exceptions, could you honestly stay off of Facebook, Twitter, the news, stay off everything electronic for 5 weeks?
But you got to back it up, though. You got to back it up, though, because you got to
I'm
remember.
being nice. I'm being nice. I'm not even talking about, oh, yeah, it's a lot worse than that. I'm just saying for this last little bit they've been out.
Right, but I'm
Let's
talking
just,
about before it even hit a courtroom, there was news conference, press conferences with the DA's office, all the way leading up into before even anybody entered that courtroom.
I'm
So you're
giving the
gonna tell
benefit
me
of a
that they
doubt.
didn't
It
see none
wasn't
of
that
those?
big of a deal then. It's become major last couple months. Plus, they're involved now. You can't tell me. I'm already sick of this place. I'm already not paying attention. And now I'm sitting back for 5 weeks and nobody's telling me anything. I'm going to find out what's going on.
Yeah,
You
yeah.
can't tell me that if you have any kind of teenager, young person around, that they ain't talking about Woody and all the stuff that he's doing. I've been laughing so hard. He is hilarious. You
They
can't
definitely
tell
been
me.
watching him. Yeah.
You cannot tell me that
But
there's
you,
going to be, I don't care if they chose 50 jurors, with them being out as long as they have and as saturated as everything is with it, you will not convince me that there's 12 jurors left. And you ain't paying me but $25 a day? Get out of here. I done found me another job. I'm not even playing with y'all anymore. So, like I said, that fury of emotions, I get it. But like I said, even throwing that out, I don't think they're gonna have enough jurors. I really don't. I
I
hope
think
it's
them
handled
jurors are
before
coming
it gets to
back.
that point.
Them jurors are definitely coming back. If they hung in this amount of time, they in there for the long haul.
They're only coming back because they have to.
Exactly. But
And
if
they're
they
gonna
needed
say,
a reason,
have you watched any YouTube, blah, 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 to do with this case? And if they're on, and I'm gonna be honest with you, even if I haven't, I would probably say yes just to get out of it. Because I'm tired of it. I would lie and say, yeah, yes, I did. Oh, you're gonna give me 30 days in jail? I'd rather do 30 days in jail than
Well, they
another
can't
year
put
of
them
this
in jail
trial.
now because they served their 9 months.
No, I'm just saying. If
Okay.
if they said we will put you in jail for 30 days, I would rather take 30 days in jail than to deal with that trial another year. That's just me personally.
see,
Give me my 30 days
I
and be
would
done.
have did this 6, 7 months ago. I'm too ADHD to be sitting there with 2 hour break, comfort breaks, and all that. I would have stood up and said, "Look, I'm confused, and I already have a verdict, so you probably want to send me home."
And then the other thing too, that time, remember, she's changing the time.
I got a grandchild I gotta pick up. If I ain't got no grandchild, I'm gonna borrow somebody's. I'm telling you. I'm getting, there's no way. After being out
But
5 weeks, there ain't no way.
the
I done
jury,
got
let
my
me tell
life
you, if
back.
the circumstances, this is what I was told by the jury service group. If the jury's circumstances have changed from the time they originally signed up for this, that they can be released from their jury duty as long as they have proof of this. Like, for example, say somebody had a grandchild since it's been 9 months, right? Somebody had a child, somebody had a grandchild, and that the circumstances change. Or a
Unless they
husband was, or somebody been diagnosed with some terminal disease, or somebody moved in, somebody moved out, somebody that got a divorce. There's been enough time, something for life happening to happen for their circumstances to change. So
Well, all I have to say is unless they chose like 200 alternates, they are not going to have enough left.
they only have
That's why
four
I'm
alternates.
hoping.
Well,
There,
I
they ain't no
come
way.
back with a
There's no way.
counterclaim. I got PTSD for sitting down here. I got PTSD. I've been secluded for a year with you guys. $25 a day. I'm not making it. My kids are hungry. I'm hungry. And this ain't working no more. I need to see a doctor because now I got anxiety. I got pizza. It could not be me. It could not be me because I'm not about to play the game. But I understand they got on there. They've been seeing it through. Hats off. But
They call me to jury duty. I get out every time. They was like, "Well, ma'am, it ain't gonna be but a 2 day." I'm like, "Nope." I get out of it every time. I don't care what I have to tell them people.
somebody got eviction notice, lost their house, couldn't pay their lights, couldn't put food on the table, no, none of that. What if they were seeking employment when jury duty came about? So all they can rely on is that $25 a day.
I think the smartest thing
Please.
for
And
that
look,
judge
look,
to do.
look, B. Brewer said I would tell them that I'm impartial.
You thought Polo was crazy. You ain't seen crazy. You put me up on there on that camera. Y'all gonna see crazy out the jury box.
It's just insane. But yeah, I
I
one of
just
those
don't want.
motions. If I honestly, and I know this is not practical, but the first thing I would deal with, since it's basically the center of everything, I would definitely have to make a clear ruling on whether the ex parte meeting was proper or improper. Then you have to make a determination Okay, let's say they determined that
It's
it was proper.
prosecutor, whatever that thing is.
Well, the
Right.
law
If they
states
say,
it's
okay, so
improper.
if they say it's proper, then you have to go to the next step. Was there Brady information disclosed that wasn't turned over to the defense? If
Mm-hmm.
so, it's a done deal. That is prosecutorial misconduct. That means this is a mistrial with prejudice. I get them mixed up. I think it's with prejudice,
With
which means
prejudice.
which means that it doesn't come back. I wouldn't deal with all them other motions. Send them boys home. Because even
I
if they
agree.
was guilty, at this point, if they were guilty and they had all of them on videotape, this has been handled so grossly, they should get to go home on technicality. And I know that sounds horrible, but that's just the way the justice system is set up. This has been absolutely horrible.
It has. It's
This is
I mean, trust me, guys,
great.
I agree with everything you guys are saying in the chat, but I just don't want them to just do a mistrial and not have it with prejudice because it's a waste because they're so petty they will try to bring it back. I'm telling you.
I mean,
Even if
Boosie is a
And
good
I could be wrong.
example for that.
And I could be wrong, Miss Sylvia. I'm sure somebody in here has kept up with it probably better than me and correct me. With the Bootsy situation, what happened was there was a legal, like a law change. That's why they dismissed his. But then they came back and retracted the change. And so that's why they came back and got him.
That
no,
was
what
his
happened is
first go
they have
around.
a hearings that's going to come about in September for that. The decision hasn't been finalized. I'm talking about the actual law that you're talking about was changed. There was no
Right.
decision yet. They're going to go before the Supreme Court in September. That's when they're going to do the argument and things like that. Then that's when they'll find out if it's going to stick. Then they can go back and reverse it. But because this prosecutor is zealous for Boosie for some strange reason, they decide to go ahead and redo the indictment. But this
Miss
time they
Sylvia,
put
they don't just by chance go back and re-indict a person. You would not believe the decisions that are made before those arguments even take the floor.
But
So
he
they
has his case is different though. He has proof that the same individual is targeting him.
right, right,
yeah.
right, right.
So his is
The guy even said wipe me down when he
yeah.
was at court.
I mean the guy is fanned out on him like wholeheartedly and wanted to bring this back again. And I believe that's going to play itself out. He has a lot of grounds to show that it's retaliatory, definitely. But getting back to the case here in chief, what about the misguidance that was given Woody in them chambers? They told him he had federal immunity too. They are not authorized legally to grant that, and they don't give that immunity.
That was a bold-faced lie. Like I said, there's so many ways they can come to the conclusion of prosecutorial misconduct. But here's the part that I find interesting. If I'm understanding correct, this judge was actually on an appeals court. So she already knows what is going to be looked at when this thing goes up to appeal, and she does not want that on her jacket. So
She's
But
I
these
don't
part,
think.
she's part
attorneys,
of the appellate in on the DA's thing. That's what she was in. The
Okay,
appellate
okay, okay,
unit.
okay, okay.
right,
Appellate
but these
unit in the DA.
attorneys have been in appellate court too, so they know what stands and don't stand. I mean, that's equal playing field. I mean, everybody pretty much in law, if you've practiced for over 7 years, at some point you're in that appellate court. So that really is not going to hold that much factor. The facts and the foundation is the factor. Their foundation, their structure was broken before it got put together, and it was broken at every part of each layer that they tried to build. And then when it got to the top, it fell all the way down. So now everybody's sitting with all these bricks around them, and they're trying to sort. This brick belongs to defense. This brick belongs to the state. It doesn't work like that. So that's what this judge has to take. This judge can't go back and even, she can watch the YouTube, but there was so much not recorded they have put on there.
But
It,
here's
it's
another
it's
thing.
just
There was so many times that he never even made a decision. He was like, "I'll do it later." Well, I'm paraphrasing, but you know what I'm saying. So
Yeah, he
she
kept
has
brushing a lot of
decisions
things.
to make. She has decisions to make on things that she don't even know about.
Yeah,
There's
that's
no
true.
way. There's no way.
Because he kept
She
brushing
couldn't
things
keep
to
up.
the side.
Yeah,
well,
and I
that's
was
what
laughing. I was
happens.
like, I had said in chat, if you take off all the comfort breaks, there's only been about 10 days of testimony. I'm telling them comfort breaks, that was just crazy.
Yeah, the comfort
But
breaks are crazy, but even with all those comfort breaks, 100 witnesses hit that stand. And you can't underestimate that or even try to get a little sliver of knowledge of those 100 that were on that stand that she wasn't there for.
these
Didn't
kind
they
of
say they're
things,
not doing any testimony for like any, what did they call it? No sympathy, not sympathy. What's the impact victim statements? That's what they said they weren't going to do. I've seen that happen on more than one occasion. They weren't
the,
supposed to let that weigh in either,
the
but
bottom
they
line is
wouldn't
this ain't,
even be here had they fought real hard on that warrant being falsified. And that man was sitting right there in that box when they broke it down word for word. And the judge that had his signature on it was the same person that was sitting in there. So you have all the parties involved right there. I would have ate that up. I would have ate that up.
There's another motion. I'm going to read it. It says request for 48-hour notice and a date certain, if able, for Mr. William to argue his renewed motion for bond. Now comes Mr.
nice.
Jeffrey Williams and by and through undersigned counsel and hereby files this request for a 48-hour notice and a date certain, if able, for Mr. Williams to argue his renewed motion for bond in the above referenced case. In support of this request, Mr. Williams shows as follows. On July 23rd, 2024, Mr. Williams filed a renewed motion for bond and a brief in support of pre-verdict bond. 2. As mentioned in said motion, Mr. Williams respectively requests this honorable court to specially set this motion hearing so that the witnesses and supporters can have notice to attend said hearing. Some of these witnesses and supporters will be traveling from outside the great state of Georgia. Wherefore, Mr. William respectfully requests a hearing on this motion and at the conclusion of the same, ask this honorable court to grant the above request relief. Boom, that's it. So, he's asking for 48 hours to have a hearing.
As should.
And honestly, if they deny what he has put up, you know this ain't about what's right.
And remember, he's on this new case. The guy that has just got turned over, and he got a $500,000 bond, and he was convicted of murder. Okay.
Not just murder. There's two other charges.
They off the chain. I'm telling you one thing. I'm going to be taking my I'm going to be driving tomorrow, but trust me, I will be ready at 8:30. I am not missing this. I have been so excited. This is going to be crazy. I just hope it's not one of them downers where she comes and be like, after getting into all this, I'm going to recuse
Excuse
myself. I
myself.
promise you, I'll fall out. I will
Oh my
fall
God,
out.
it would
I
be
will be
terrible.
done.
It
I
will
will
be
be done.
terrible if she does that.
Because I honestly don't think she realized what she was coming into. Because when you're a judge like that, you have your own stuff to handle. So she doesn't have time to be watching recaps and all this kind of stuff. So I honestly don't think she realized the extent And I think that she still probably doesn't have a clue until they get up there and start arguing. It's gonna be ugly. It is gonna be ugly. But there's no way it, like I said, even if all else fails, they're not gonna have enough jurors if nothing else. And I think they know that. That's why she was saying go ahead and look at plea deals. And at this point, the defense would be crazy to even entertain a plea deal unless it's something crazy like 100 hours of community service and no felony. I would take something like that. But you hear them plea deals that they gave out. When was that, Miss Sylvia? About a
Mm-hmm.
month and a half, 2 months ago?
Mm-hmm.
And didn't nobody take them? I wouldn't have either. Did you hit them things? Would sound like it'd be worse. Mm-mm.
It's 20, 15 years, 20
If that's
years.
mm-mm, I
And
wouldn't
some of them
entertain
have
none of
to
that.
serve time.
Mm-mm, nope. They sound like they was crazy. I'm like, why would they? That
Even
was
offer
nuts.
that. But they didn't take it. None of them took it.
Oh, Miss Sylvia, they hitting your channel with ads. I promise you, it seemed like every 7 to 8 minutes. It's crazy. But
That's
yeah.
a good thing for her.
Yeah. Money. Oh yeah, dollar signs. But yeah, that's just kind of my take on it. I just think that, like I said, I think Fonnie is looking for the long thing. She won't. They probably want a mistrial now. She's not going to be able to take an L. But if Brian is compelled
But
to hand over all that stuff,
a mistrial for them is an L.
but no, here's the thing: she's got to come back. She's not going to let it sit. It's not going to sit right with her. Look at her personality. It's not going to sit right with her. She will bring it back. She's going to have to fight to bring
That's
it
why
back because look at all this money.
that's why I said it has to be with prejudice for me to even accept a
See,
mistrial.
I
Yeah,
think
yeah,
the
yeah, yeah.
opposite. I think that they're going back to that office and sitting down with their boss and saying, "Look, what are we supposed to do now? Are we calling it?" And she says, "No." We go back again. Bad court day. Go back into that same office. What we doing now? Come on, it's
Because remember,
getting
she got an election in November.
She just
correct.
trying to make it till
Prolong this
November.
thing
That's
to
all she trying to
September.
do.
Huh?
After November, she don't care what happened.
Yeah, so that's why she's trying to prolong this until November.
Yep, yep. She don't care what happened after November. This is crazy. I've
Hey,
never seen anything
Renee.
like this.
Renee
Hey,
came
Miss
to ask
Sylvia.
us. Hey, how you doing?
Pretty good. I have a question. Something that we're talking about the case if it were to be dismissed. Um, what will happen with the plea deals with Tick? Like, do those things go away? I do not know the
No.
answer to that
No,
question.
they
Mm-mm.
they done.
You take a
Remember,
plea,
they
you're
done.
done.
They done. Their stuff is they already pleaded guilty. They will not come back unless they do a habeas corpus, which is gonna be within that 4 years, and they're already into their second year of taking the plea. Because they got their plea back in December 2022.
Because
So
I just would find it hard for them if they did bring it back and the case has already been dismissed. Like, how would that testimony change from Tick, from DK? Would Woody, like, would that testimony completely change?
They would definitely not use some of the stuff they did. They would, I mean, basically, it's like they get a second chance, but they have the advantage of having the transcripts from what happened with this one. So, a mistrial, if it comes back, it actually kind of, sort of gives them an advantage. Um, I don't know. I just think that this thing's going to be done. That's what I'm going to put out there, that this thing is just going to be done.
with prejudice.
Yes, with
Because I
prejudice.
don't want to. I'm telling you, I don't want to hear the other reason.
I
And what
agree.
they need to do is they need to quickly, after it's dismissed with prejudice, they need to quickly file a lawsuit against them for malicious prosecution. That way, if they try to come back, it'll look like retaliation. That's exactly what that's what I did in my case. But that's what I would do. That's the even further protection. But I don't
Okay, I'm
know if
sorry. Hold on, y'all. I've got a super chat. I'm sorry, I wasn't looking at my computer. Um, Melanie
Melanie.
Lawson says, I believe it will be a mistrial with prejudice or a general mistrial. Oh, Lord, don't say general. The youngest juror is no other juror. It will most likely vote not guilty.
That judge is going to have to make a solid ruling on that ex parte meeting.
She can't.
Why?
She wasn't there.
Didn't they put a motion in basically asking for that to be looked at again on how
No,
it was ruled?
I don't think so.
Well, it wasn't ruled. It was just Judge Krauss' opinion. Just
Opinion,
because
yeah,
her
that's
opinion said that it was proper. However, the case law states something different.
right. But
So
didn't one of them put in a motion saying basically we need you to look at this and make a ruling on this because it wasn't right?
I think Steele did that.
I think it was still, yeah. So that I think needs to be handled before anything, because that's just going to be a trickle down effect. If that is considered improper, or like I said, if it's considered proper, but Brady was done in there or misconduct, that's going to be the best way. Put it on the prosecution because they deserve it. Prosecutorial misconduct, dismiss with prejudice. I don't care about no bond hearings because I'd rather them do it that way and let them boys go home for good without all that other extra stuff.
But usually another judge doesn't overrule another judge's thing unless it's a go to appellate. You know that, right?
But they can't. You got to understand, Miss Sylvia, one thing that I don't think anybody's disputing, this case is something like nobody's ever seen before. They are setting so many precedences with this because this is just crazy. And the thing is, like, how do you come in and sew up all these decisions that weren't made? Oh, well, we'll deal with that down the road. Oh, we'll deal with that down the road. Oh, we'll do it. So now it's down the road, and she
But
don't have
Didi, I'm
no
telling you,
clue.
they do not go against another judge unless it's an appellate group does it. When it goes to Supreme Court.
But with
yeah,
the ex parte,
that
it
ain't
wasn't
gonna
be going
happen.
against. That was an opinion. That wasn't a decision on the ex parte. She just kind of glazed over it. She
But
really
she did
didn't
do it. She
say.
made a ruling. She made an order. She made a ruling.
Right. She recused the judge, and ultimately that is what they were asking for. So what they had asked for, they were granted that. So
And then
I don't.
she gave her opinion of saying that what he did was that's parte part. There was nothing he did wrong. But the
I
part he
have to
did
go
wrong was
back.
when he tried to justify himself, which he shouldn't have done it.
I could have sworn that one of them motions was something about we need you to relook at this ruling
Yeah, but
about this
she's not going
ex
to
parte.
go. I'm telling you, even though they put it in, she's not going to go rule against another judge. She's not.
And really it holds no significance because they said it's incomplete anyway. I mean that was put out there publicly that those
Right.
transcripts are invalid anyway. So ultimately the goal of that was because they wanted Glanville recused. Okay, that's done. Now you got to go on to the technicalities. So that they're past that point. The technicalities is all these other things that they're fighting for right now. But there's also a whole bunch of other motions that have already been filed for all the other dents in the foundation and the structure that they're saying that need to come back up because it was incorrect due to case law and what the Constitution says what everyone's right is. So
Well,
there's a lot of things.
one thing I promise you, no matter what Judge Whitaker is getting paid, it ain't enough to deal with what she's dealing with right now.
That's true.
I
Amen.
wouldn't, I
It's
wouldn't,
very stressful.
put my worst enemy in her shoes right now.
Well, I mean,
That's
why you
crazy.
think them other ones recused real fast, quick, fast, in a hurry? They didn't want no parts.
But,
You can't tell
she,
me they didn't have the basis of what's happening. They know why the courtroom is backed up. They know why this judge only had 26 cases assigned, and they had a whole bunch more. The statistics are there, and how
With
many cases that are in the courts right now being seen by all the trial judges and how many are backed up at that jail, the numbers ain't mathing. They're not
I
mathing.
I don't think she would have took this case if she wasn't trying to bring attention to herself because of that. What they said, she's up for some kind of promotion or something or whatever, like a what is it, Supreme Court seat or whatever. Um, and this would be kind of like the icing on the cake. But I honestly don't think she knew how bad this was because judges don't misbehave this badly. This was just, it's like he had to work to behave this badly. It's crazy. And I bet you if it would have went past this judge, all them other judges, they already had their letters of recusal already drawn up. All they were going to have to do is drop them.
It's kind of like what Steele said when he was addressing Glanville. He was like, "You're not in a bubble. You see what's going on in this courtroom."
Right.
I don't think she knew entirely.
She didn't know
But you can
entirely
go and
because
watch Miss Sylvia's playlist and see.
if I hadn't seen it myself, I would have sworn, see, them just some fans and they over exaggerating because judges don't do that kind of stuff. I honestly, that would have been my approach. Judges don't do stuff like that. You just don't understand what's really happening. There's no way I would believe that a judge would act the way he did. And plus, you got to understand, everybody is saying he was not like this. He was a good judge. They respected him. All you hear is good stuff about him. So there's something about this case. I think it'll come out eventually, but there's something about this case. I mean, I've been trying to look like, is Love like a Eastern Star and he a Mason? Like there's got to be something that we haven't brought up yet that made him so out of character from what everybody else is saying.
Well, my good people, we shall see tomorrow what is going to, all we're doing right now is sitting here speculating because we don't know what the
Yeah,
fact was going to happen tomorrow. All we
we
can do
don't.
is hope, pray, and wish for the best in this
I
whole.
know it's going to be interesting.
It definitely is going to be interesting because it's something that we have never seen before, and it's going to be off the chain inside the courtroom, and you're going to see everybody's mama and their daddy, everybody going to be in the courtroom tomorrow.
And all I'm going to say is I hope that it starts with everybody on the defense being on time and Love and Hilton walking in at 9 o'clock. That's what
No,
I'm hoping happen first.
they always come in first. They always there early.
I know, but I'm just saying things happen.
That's true. But they always in early, always. Unless they're not, one of them's not coming in. But most of the time I
Right.
see somebody. I was seeing in the chat, somebody said Helinski's gone. Is that true, y'all?
Who's gone?
One of the attorneys on that, because he used to always say he don't have anything to say. He don't have anything to say. He said he's keeping his mouth closed. He's keeping quiet. That's what he used to always tell me.
Is
What
that the old gentleman with the gray hair?
No, it's the young guy, the tall Caucasian guy, the real tall one, not the bald head one, the one with the longer hair.
Yeah.
Did somebody say he's gone?
This is going to be out of control. I am so excited.
It's gonna be live in action. She's got too much on that plate that she can't even begin to try to piece some stuff off and focus on a small section, because if she focuses on one, there's still 59 more issues behind it, and there's going to be all these motions. And
She's got to come out of this looking good. That's what she's trying to figure out. Because she already, I'm telling you, they ain't no jury. They're going to ask them people them questions. They're going to be like, yeah, I watched all Woody interview on, watch. Oh, my niece
But
came to
then
my
they're
house. She
gonna
was
get
talking.
in trouble for doing that. They can't watch
Right. No juror's
You don't
gonna
get
come
you don't
out.
go to jail for that part.
Yeah, no juror's gonna
That's what
come
I was
out and
saying.
put themselves in jail. That I
No, no, no,
think.
no, no. I'm sorry. I didn't make that clear. I'm talking about when they ask the jury the question.
No,
When they
jury's
come
They
not
back.
gonna
say
say
yes,
why
they go to
no
jail.
women. They're not gonna
I
say
would,
that. That's violation of their
but what's
admonition, whatever that word is.
I
Yeah,
need to
Admonition.
look
they're
that
oath.
up.
They're
What's
violating
the
their oath.
maximum time they can send them jurors to jail?
Ain't
20
When
none
the
of them
days,
trial,
jurors going to jail.
20
Ain't
days in jail.
but look though, if they put you in, even let's just say they did it for until the trial over, the trial gonna be over, so they ain't gonna have to serve no time.
Yeah, but the point
'Cause
is
there ain't gonna
going
be
to
enough
jail for
juries,
this. Who
the
wants to go
jurors.
to jail for this?
they
I
would
rather,
have already been
I
dead.
rather find something that's my lifestyle change than anything else. I
I
would not.
totally agree. I would not want to be in
But I'm
Fulton
just
County.
saying, some kind of way, rather it's lifestyle change, rather it's I messed up in this or this, that, and other. There's not the bottom line. My bottom line is there's not going to be 12 left.
That's what I've been saying from before. I told you that back in April.
That judge knows that, and she's gonna do all that work just for them to come back, and then there's not enough, and they have to let it go anyway. Something's gonna happen before that jury come back. That jury's not gonna have to come back. I'm telling you. They already know that if it's based on the jury, they ain't gonna have enough. I'll adopt a baby if I had to.
Well, anyway, guys, I'm about to get off this live. Thank everyone for their participation, but I have to get into bed.
But thank you, Miss Sylvia, and hopefully next time I come through Atlanta, we'll have time to meet and eat. I love to eat. I
Yeah,
love
me too.
restaurants. I love to eat. I love going to the restaurants that aren't chains, and I love to eat. So we definitely have to do that.
Y'all got
Sounds
me
good.
fired up now. I'm still ready to go.
Go
And
where?
you want to go to bed?
No, I have to. I got to get up in the morning because I want to be down at the courthouse on time, and I'm not wasting my time with you guys.
And that
Yeah,
does
see,
start early.
I
I'm
pick,
sure.
I picked up a load in Durham, North Carolina at 8 o'clock this morning. And it's got to be in Corpus Christi, Texas by 10 o'clock in the morning. So I'll be driving.
Safe
But
travels.
y'all have a great night. I am
You
out.
too.
You have a good night. Be safe on that road out there.
Bye,
All
y'all.
right,
Thank you.
ladies. I will see you guys later. I'm gonna bounce y'all. All right, see you guys.
All right. Good night. Good night. I'll go live then. Forget.
All right, y'all. Let's do our prayer. May the Lord watch between me and thee while we're absent, one from another. You guys have a great and wonderful night. I'll see you tomorrow if the Lord is willing, okay? Night, night, good people.